be certain except death and taxes for the past decade. April 16th, the day after tax day, well, traditionally tax day, National Healthcare Decisions Day has been dedicated to NHDD. This day is generally celebrated throughout the entire month of April, as we believe it is truly that important. I guess I should ask, can everybody hear me okay too? You can just, if those of you on screen, yeah, perfect. Okay, awesome. So what National Healthcare Decisions Day is, it's a nationwide initiative to encourage people of all ages to share personal wishes regarding their future medical care, and for healthcare teams and facilities to then respect those wishes, whatever they may be. So without further ado, today we have the luxury of having Ben Adams, an elder law attorney of McCarty Law, who in Appleton, who joined there in August of 2019 after practicing at Adams and Woodrow and Neenah for over 30 years. He continues to emphasize elder law, special needs planning, guardianships and alternatives to guardianships, nursing home and long-term care issues, advanced care planning for healthcare decision-making, and estate planning in his practice. He is also a member of the Fox Valley Advanced Care Planning Partnership, which was established in 2016. So without further ado, I would like to welcome Ben Adams. And for those of you with questions, we ask at first that you put them in the chat until we and Ben open up the discussion more for a more interactive based session. So without further ado, Ben, the floor is yours.
Thanks, Josh, and good afternoon, everybody. Hope you can hear me. Looks like we've got a great sign up and turnout. It's nice to see so many familiar names from all of the volunteer efforts that so many of us have been sharing in for the last 20 to 25 years. And it's great to have this week. I appreciate Josh and Ellen from the partnership organizing this and putting it together. Josh is our intern, and he's been a great addition to our efforts. I do have a couple of questions that people have sent in ahead of time. I'm fully prepared to talk as long as I have breath. I want to get to the questions that were submitted pretty quickly here. And we'd just like to kind of give a quick overview. I mean, what should we plan for? What do I need to have in place? Obviously, this week focuses on healthcare decision-making planning, but people should also have a couple of basic, I guess, non-healthcare legal documents in place. You need a durable power of attorney. So if I become, if it's inconvenient for me to handle my finances or legal decisions, in my case, I've appointed my wife or our daughters to become agents of mine to handle financial and legal matters until I either revoke that or I pass away. And a power of attorney for healthcare or medical, healthcare or financial decisions will cease to have legal ability if I pass away. It would also stop if I revoke it in an appropriately legal manner. But in addition to that, I need some sort of mechanism, or most people do, to pass what assets I have on to my beneficiaries if I were to die. That can be done through beneficiary arrangements. If I have a joint account with my wife or my daughters, and one of us passes away, that account goes automatically to the surviving owners. And it doesn't matter. I may have a will that says I'm leaving my estate to Sue and Jim O'Neill. But if my will says that, but I put Josh and Jean on my account as beneficiaries, that account beneficiary arrangement is going to supersede whatever the will says. If I have an asset that doesn't have a beneficiary on it, then that's going to go according to my will. And if I don't have a will, that'll go according to what the state law in the state where I live when I die or where I'm a resident provides. So that's kind of a very quick overview of the financial arrangements that are in place or that we can put in place. You can also do a living trust or a revocable trust. That's kind of maybe a little bit outside of our parameters today, although if questions come up, I can certainly talk about those too. So I will, I guess, go on to the questions. If you do have a question, if you lower your cursor down to the bottom, you may be all Zoom experts by now, this far into the pandemic adjustments, but please submit those through the chat. Or if you want to ask it in person, you can raise your hand somehow down there. I'm not exactly sure how, or wave feverishly if you turn on your camera, and we'll do the best to let you come in that way. So one of the questions was relating to selling a house. So this one is a common question that many people have. And the question was, if I sell my home, do I have to pay income tax on that? Is it a taxable event? And the IRS in the state of Wisconsin does have rules for whether the sale of your home is taxable or not. As a general rule, if it's my home and I've owned it and occupied it for 3 of the last 5 years as my principal residence, then it's not a taxable event unless if I'm single, I have made more than $250,000 of profit over and above what my cost of that home was. If you're a married couple, that limit is $500,000 for a married couple selling their home. And again, you basically can't do it every year. You can do it every 3 years if you do it right. So the answer is, if you're not sure, then you better call your accountant, call who's going to do your taxes. But as a general rule, if I fit within that 250,000 or 500,000 profit arrangement, then if the documents are completed properly as part of the sale closing, then you don't even have to report it on your tax return. And everything I'm talking about today applies to Wisconsin. It doesn't apply to the UP or Minnesota or Illinois if some of you are zooming in from those other lands. Another question that we had was, what can I do to take care of, the question was, what can I do to assure that whoever I leave property to or dollars to, that they can cope with taking care of that themselves? And I think the question was pertaining to, how can I set up an arrangement if the person I want to benefit maybe isn't a real good decision maker or has legal disabilities or disabilities in managing their own decisions. That might be a situation where you'd want to put some kind of trust arrangement into your will or into your planning documents. So if I want to benefit Josh, and we'll use Josh as our example today, but I'm concerned about his ability to make decisions or capable decisions, and who's not concerned about their children or the younger generation making good decisions. I could put some strings on that, but it's easy to say I'm going to set up a trust arrangement for Josh. But if I set up a trust arrangement for Josh, then we need a trustee. We need somebody that we are going to delegate that authority to. And it's easy to say I want a trust, but it's harder, much harder often to say this is who the trustee is going to be. And it probably isn't going to be Josh's brother or sister, or my other child to take care of the decision making for this child. That can be a very complicated arrangement to discuss. There is in Wisconsin a really good special needs trust arrangement, a pooled trust called the WISPAC Trust, and we can send out information about that, or you could look it up online. It's called WISPACT.org, and that's a specific type of trust arrangement that's set up for people who have to qualify for disability benefits such as Medicaid or SSI. So that's a great resource we have in Wisconsin. If you have somebody who's younger and you want to name your brother or your sister as their trustee until they turn a certain age, then, but they don't necessarily have disabilities, then you could talk to a good estate planning or elder law attorney about options relating to that. So hopefully that's kind of at least started to give some information to the person that asked that question. I'd be glad to have you submit another variety or version of that question as we're talking if you want to. I am kind of looking at the chat periodically to see if there are new questions there, and I haven't seen those yet. A question that came up or was posed last week, one of the early registrants talked about, what if somebody has someone in the family with a disability? You maybe have more than one child and one of your children has a disability. What do you do then? What should you be thinking about? There's another terrific organization called WisconSIBS. So WIS, I'm sorry, I can't spell. WISCONSIBS. And it's also a nonprofit organization that was founded in Appleton. And if you look their website up, they have great resources to help you plan for the future for somebody in your family that has a disability. And they are an organization that I have referred lots of families to over the years. And I wish, more attorneys and more members of the public were aware of them, because, the old-fashioned plan, the historical plan for somebody in the family who has disabilities was their brother or their sister will do what they can as life goes on when the parents of that person with a disability are gone. But that plan, sometimes can work, but it has its limitations, obviously. So I think one of the things to do is to look into how can we talk about this as a family? What resources are there out there that as a family, while we're all still here, we could try to get some experience with, and then what's going to be the plan when the person or people who are making the most success, I guess, to assist the person with a disability are no longer able to do it. What's the transition plan going to look like? And not just leave that for a sudden crisis when something happens to somebody, one of the primary people. I won't ask for a show of hands how many people have done their planning for healthcare decisions. We do have some great programs later in the week for people who have more specific concerns about that. I want to look at what's in the, okay, so Ellen posted the list in the chat for the WisconSIBS organization. There's a question, if I take money from my retirement funds to prepay for funeral or burial arrangements, do you pay tax on those funds? Anything you take out of a retirement account, an IRA or a 403B or a 401k, if somebody takes money out of that and takes that money directly, that's going to be taxable income in the year that you take it. So before you do make any withdrawals, you might want to talk to whoever your tax advisor is about, this is what I want to do. Is there another way to do it? If you're over, it used to be 70 and a half, and I believe that's one of the elements that changed, at least temporarily, to be 72 years old now. You can, at a certain age, those of us who are elderly, including me, can direct our IRA withdrawals, our required withdrawals, to charities. Instead of taking it out and giving the charity the money, you can redirect it directly from the IRA to the charity under certain circumstances and not have to report that as income. If you do that, it could be a good tax planning step, but you can't double dip. You don't get to direct the money over there and take a deduction for it. You're simply directing what's called your required minimum distribution. For those of you under those ages, I'm not going to tell you what a required minimum is, because you don't need to know till you get to be our age, but those are all tax issues. So that is a way you can do that sort of thing. You can direct that taxable, what would have been taxable income, directly to the charity. Somebody asked a question about the difference between an ABLE account, ABLE account, and a special needs trust. There's a relatively new development in the law and tax that's called an ABLE account. Somebody who wants to set aside money for a person that, generally speaking, needs eligibility for public benefits can create or add money to an ABLE account. And those accounts are not they're not counted as assets for most, but not all, public benefits programs. So I can have money in an ABLE account. I can still be eligible for Medicaid or SSI. Those are two specific programs that, generally speaking, say that an individual cannot have more than $2,000 and be eligible for those programs. And there may be a couple of wiggle exceptions for that. But so my parents can put money in an ABLE account. I can take some of my, if I inherit money as an example, and I want to retain eligibility for one of those programs, I could, within a certain period of time, create and fund my own ABLE account, or I can put money into an ABLE account that someone else set up for me, potentially. And then that's no longer an asset that would make me unable to receive my Medicaid or SSI eligibility. Before somebody does something like that, you want to be sure that you've looked into it to the point where you understand that it's a good step to take, and you understand how that account or those assets can still be used for that person's needs. If I have my own ABLE account, I have some discretion. I have full discretion over taking the money out and spending it. And nobody's really going to tell me when I pull money out of the ABLE account whether the way I intend to use it is good or bad with respect to my eligibility for these programs. So I may be making some mistakes in how I spend that money or what I spend it on. If I have the money in a WISPAC trust account and I want to pull money out of there, I have to request it. I can't just write a check. And the WISPAC staff are going to catch virtually all of the mistakes I'm going to make before the money actually gets used in that direction. So I do think the WISPAC trust has some safety in it that an ABLE account doesn't. So, but you know, again, that's something that is a great resource. It can be used very helpfully for people or in a helpful way, but there are some limitations also on what a WISPAC trust or a special needs trust can pay for.
Ben, if you don't mind, if I jump in real quick. So
Sure.
if we do have questions, which I'm sure we do have more questions, just feel free to just make sure to unmute yourself and then go ahead and ask Ben the question. Otherwise, if you want, you can still put it in the chat too, but just making sure for when people have questions, just make sure you're unmuted, and then just maybe if you want to just say your name, and then Ben can help address that as well. So yeah, just going forward. All right, back to you, Ben.
Thanks, Josh. Yeah, otherwise the risk is I just keep talking, which those of you who have known me for many years realize I'm usually going to do. And then there was I don't know if we'll have a chance to post it, but there is a handout from our law firm that has the basic elements of, or the basic items of estate planning that people should be thinking about, which would be power of attorney, as I said, wills, marital property agreements. If you live in Wisconsin, that may be a helpful tool for you. If you don't have children, or if your children are going to disagree about what your funeral or burial or cremation arrangements are going to be, you can do a legal document where you can designate who your authorized person is, called a authorization for final disposition. Difference between living trusts and wills we talked about a little bit. So let me just look at some of these questions here that came up a little later. If I'm the power of attorney for my parent, say my mom, and dad is deceased, and I'm a co-trustee with my mom on her trust, but mom wants to delegate her decision-making authority to for the most part to me. Normally you can do something like that, but if it says that Josh and Ben are the co-trustees, then generally If it says the word and, then Josh and Ben are going to have to make those decisions jointly unless Josh decides he's going to resign. So there are usually steps where if you want to go from 2 decision makers down to 1, either through a resignation or the document may say if Ben is no longer able to make decisions, then it goes to Josh being the sole decision maker. There may be legal language that some document that needs to either be activated by a physician's determination or a resignation. And usually those have to be not, you don't just find those on the internet. You'd want an attorney to draft those documents, or sometimes I've had to draft for the physician the language that we'd like them to put in their report or their determination, so that then the broker or the bank is going to rely on that to let the other person make decisions. And the other part of that question was, should I take my mom off as the trustee? And again, mom has the right to resign as trustee, but I can't really take mom off of the document as trustee unless mom either meets the guidelines for the physician to say mom is no longer a trustee, or mom wants to resign as trustee. Very often the person who's appointed as an agent for someone, as their power of attorney or their healthcare decision maker, thinks that they're in charge. And when I appointed my wife Debbie as my agent, I didn't resign as my own decision maker. I just said that Debbie can also make these choices for me. And if for some reason the person I appointed is no longer suitable, I should have the right to be able to take them off of that document. But sometimes I think I'm still making my own decisions in a capable way, and I'm really not. So that can bring the tension into who should be my decision maker. And should I mean, I hope when I get to a point where I want my wife or children to make those choices for me, that I'll be sensible enough to just hand that over to them. I've seen many clients do that. I've seen many clients who don't recognize, or many illness issues that intervene in somebody's decision-making capacity and makes them not really a good decision maker, but prevents them from understanding that process and that deficit. So just want to take a quick look and see if anybody is waving or unmuting themselves. Otherwise, there are several more questions, and I'll move to the next one that I see. There's a question here about, is there a CBRF, which means community-based residential facility, considered a healthcare facility per statute? And I guess depending on what statute you're asking that question about, I'm not sure I can give you a clear answer to that. So if you can repost a little bit more of a clarification there. And lately, somebody else said lately, I'm seeing agencies listed as a power of attorney for healthcare agent. Is that permissible? I thought it needed to be a specific person listed rather than an agency. I think that's correct. If I do a healthcare power of attorney document and I want to appoint a person from an agency listed to act as an agent, I can do that if that person and that agency are willing to let them be the decision maker. But you can't appoint an agency itself to be the decision maker. I'm not sure that was always perfectly clear in the law, but I believe it's clear the way the law is actually written. Okay, so then the clarification on the part of the question was for a community-based residential facility, which means a certain type of assisted living facility, just for people who aren't familiar with that terminology. And the Wisconsin power of attorney document does require, or the Wisconsin power of attorney for healthcare law does require us to specifically give authority for my agent to admit me for purposes other than short-term rehab to a healthcare facility. If you look at the state statutory form, that one has two different questions. One is if I'm giving the authority for my agent to admit me for permanent care, so to speak, in a nursing home, you have to say yes or no to that. And if you don't say yes, you said you have by default in Wisconsin said no. And some of the documents don't specify between a healthcare, a nursing home facility and an assisted living or a community-based residential facility. But if the agent is supposed to be able to admit somebody for that without going through the courts, then that power has to be clearly stated in that document. So if it says my agent has the authority to admit me for other than or for long-term care, then my agent can do that. If it's not as clear, then it's going to be determined by the facility where I am and are they comfortable with my agent having the necessary authority. But normally, yes, that would include a community-based residential facility. So I'm trying to see if I missed any of these. I think I'm kind of caught up. So what kind of, how many, I guess I won't, again, we won't show an, ask for a show of hands, but I'll give a couple of additional guidelines. For those of you on the call who have done your estate planning in the past, but maybe haven't looked at those documents since you signed them, which is the case for most people, for most clients. If you've done that planning more than 3 or 4 or 5 years ago, it's probably time to pull those documents out and read them and at least take a look at who did I appoint to be my decision maker and who's my alternate person. If any of us are down to maybe just having one person authorized, we had a first choice and a second choice once upon a time, and somebody's passed away or become unsuitable, then I think it's time to revise those documents. If you look at them and in my case, I'm going to be retiring from practice of law at the end of May this year, so a little over 6 weeks from now. Yay for me. But you know, if the attorney you worked with to draft your planning is no longer practicing, then it might be a real good idea if you would take a read through your documents and maybe contact that law firm and give some thought to who you might want to become your the person to review that and tell you whether it's up to 2021 or 2022 legal standards. It's even things that I did for clients in 2015 or 2010. If I'm talking to those people now, I'm saying, you know, the laws have changed a lot. There's not much we can be sure of life, but death taxes and the fact that the laws are going to change are 3 things that you can count on. And documents that were signed some time ago, often the language was good for the year that we created that, but it's not potentially sufficient for often some of the financial institutions have now merged and changed names. And the bank down the street on the corner used to be able to, you know, be a lot more flexible in what language they would rely on and let your agent take action under than they are now. So I really think updating these documents, I usually tell people every 5 years is a real good idea to at least look at it. And then if you're concerned about things or there's been a change in somebody's abilities or somebody's health, or there's been a death or a divorce, those are common times where it makes sense to take a look at these things and see if you should do some revision to them. So I am just going to take another quick chat look here. I assume those will be jumping out at me if there's still some more. If anybody on the call, it's possible you may have a house that's not in Wisconsin. You may have a piece of real estate in the UP or a place in Florida or somewhere else outside the borders. If that's the case, you probably should be looking at talking to somebody about doing a trust instead of a will for your plan, because um, the, I guess a common misconception that people have about wills is if I write a will and I sign it and it's legal, that my estate will not have to go through the probate process in the courts. I hear somebody tells me that at least 2 or 3 times a week. And actually a will is the roadmap for how the probate process through the courts will take place and who's going to be in charge of it.
He's
So
off, man.
my will
He's off.
nominates somebody. Go ahead. Is that a question?
No, I think she was talking to her dog or something, or I don't think it was a
Could
question.
be. Okay, so but relating to a will is a very useful tool, but the process of putting a will into effect so that it will actually complete its job normally has to go through the courts. Now, if 2 people are married and they have a will and they own things jointly, if one of them passed away, there's usually no probate required to transfer assets to the surviving owner because that happens by automatic joint ownership. But if a single person or the surviving spouse would pass away, that's the point at which, depending on their assets, there may be a probate needed for their will. And in another type of situation we see a lot in our area of practice in the elder law field is if we have a married couple and one of them, for example, has dementia, so they're increasingly over time becoming less able to handle their own decisions or just do day-to-day functions, and the other spouse is becoming a caregiver or caretaker. Very often we worry about, well, what if the one who needs the higher level of care, if the healthier appearing spouse happens to pass away first or something significant happens to her health or his health, the one who's in need of services is not going to be remaining independent. They're going to have to maybe either bring additional care services into their home or more likely go somewhere to assisted living or a nursing home for the care that they need. And we can do we can do advanced planning about how their assets can be better handled. And very often that advanced planning involves us doing a will for the healthier seeming spouse that'll have a special needs type of trust arrangement in that will for the surviving spouse if the healthier one died first. So I don't want to go in great depth to that, but that's a situation where in Wisconsin, at least, we can use the probate process to preserve assets that can be used for the surviving spouse's needs during their lifetime instead of having to be used up so rapidly that there's nothing left for that spouse when they have spent a fair amount of time in a care facility. So a couple of questions that have been posted since we last looked. One is, can a person write their own will, and is there an acceptable form? And yes, a person can write that. You may write your own will. You're not required to have a lawyer do it. And I've seen some wills that people have drafted on their own without a lawyer that have been pretty clear and pretty, quite usable. I've also seen wills drafted by people without a lawyer that are completely terrible and they're going to create more problems than they solve. But on the other hand, the third hand, if I've got 3 hands, I've seen some lawyer drafted wills that aren't very good either. So it's one thing to have a lawyer draft your will. It's another thing to have a capable lawyer do any work for you. You have to be cautious in finding out how capable that lawyer is. So that kind of leads to the next question in the chat, which how does somebody go about finding a lawyer? Well, word of mouth can be good. Ask the people that you know and trust what their experiences have been with the lawyers that they work with. I am an elder law attorney, and I have a great affinity for elder law and special needs attorneys. The state bar has an elder law section of the state bar, and people belonging to that section tend to focus on elder law, which is sort of like estate planning, but with more of an eye, I think, to while I'm still here, and not so much not as much focus on just when somebody dies. Because I've always told clients, if you die, don't worry, your problems are over. It's if you don't die that they're not only somebody else's problems, but they're still mine. So you want to be sure that you get an elder law attorney, or somebody who's a member in the elder law section of the state bar, or maybe a member of the National Academy of Elder Law Attorneys, which is another organization I belong to. And I think those types of attorneys seem to have more education and devote more of their time to staying up to speed on the kinds of law changes that impact people with special needs, people with disabilities, and those of us who are aging. And if you look around the sign up today, you know, I used to think middle age was somebody a lot older than me, and now middle age sounds pretty good to somebody my age. Are there, so yeah, I guess there's no guarantee that finding a particular lawyer is going to give you a good result. But I think asking the lawyers some questions, finding out about their history, their interests, and how long they've been in practice is always a good idea. And when you're working with lawyers or any professional, you want to find out how are your fees going to be charged? You know, what is it going to be, an hourly rate? Is it going to be a project for the amount of services? So before you send off a blank check, so to speak, to any professional, you want to get an idea of how they're going to arrange for and bill their services to you. Are there limits on types and amounts of asset transfers? Yeah, there are. The most common type of sort of limit that you hear about, that most people have heard something about, is if you transfer gifts to other people in excess of $15,000 to a person in a calendar year, that's supposed to be a quote unquote taxable gift. And those are, it doesn't mean that you get penalized if you give somebody more than $15,000. Unfortunately, in my area of practice, it also doesn't mean that because the IRS says $15,000 is an amount that you don't have to report as a gift. For nursing home issues, $15,000 is not an acceptable gift to give away if you're going to be in a nursing home within the 5 years after you make gifts. So there are different sets of rules that apply for tax law versus long-term care concerns. So before anybody makes any gifts, I think it's good to get some advice from either an attorney who's knowledgeable or a tax professional who's knowledgeable. So, and that would apply to any type of transfer during your lifetime, and whether it's a gift. Okay, Ellen put the National Academy of Elder Law Attorneys up there. Gosh, it's 5:40.
Yeah, so
yeah.
So I guess we can begin to wrap up now. Ben, if you have any final thoughts too, that would be great too, and then we can point people in the next direction as well.
Okay. Yeah, and I kind of wish on the one side we had more questions or more time, and I apologize if some of my information isn't as clear as you might have wished it to be, but these areas are pretty complicated. So I think if you have power of attorney documents, as an elder law attorney, one of the important provisions that we always talk about with clients that we're doing power of attorneys for finances for is, do you or do you not want your agent to be able to make gifts of your assets or transfers of your assets, either to your spouse or from you to your children? That's a huge issue. And most stock power of attorneys, the state statutory power of attorney is a good example, do not authorize your agent to make any gifts, not to charity, not to your spouse, not to your children. And yet most people think if I do a power of attorney, I am giving my agent, or I maybe do want my agent to have that right and that ability. So there are a lot of reasons why you might want people to have the right to make gifts. There are good reasons why you might be afraid if you're giving them the right to make gifts of your property. So that's something that should be definitely discussed with your estate planning advisor before you decide what type of document you want. The other thing I would say is you want to have some kind of a will, you want to have some kind of a healthcare power of attorney, and there are going to be some really good programs coming on the next few days to help us with those. So I will call it quits there and throw it back to Josh and Alan to tell you what's coming up tomorrow night.
All right. Well, Ben, I just want to say thank you to you and McCarty Law for being so cooperative with us and to hold this event. So yeah, a round of applause for Ben. So thank you so much. And so just to go over some resources that are going to be good going forward for you guys that we can take away from this. So the National Academy of Elder Law Attorneys. So that's www.naela.org. If you want more information on Ben or what they're doing at McCarty Law, you can go to www.mccartylaw.com. And then if you want to seek out an attorney or elder law attorney /attorneys. Other good resources to use include WISPAC, so that's www.wispact.org, and then Wisconsin SIBS, so Wisconsin and then SIBS.org for future planning for families and people with disabilities. And then for more information going forward, so on other events, monthly classes, and more to help you with other legal documents and whatnot, you can go to our website at fbacpp.org, or you can like us on Facebook at Let's Talk Fox Valley. So going forward, you also see our next events coming up, as Ben just referenced, tomorrow at 5 p.m., same time, same Zoom link. We'll be having Dr. Timothy Jessic of Theta Care on, and he's a palliative care physician, and more about advanced care planning from a medical perspective. So I thank everybody for coming today, and I thank Ben specifically as well. But also be sure to check your email after this, as we will be admitting a survey. It's more so just for us, as we want to make these events a more commonplace. And then just more feedback on the event as a whole. And also, if you do enter to win, you get access to possibly winning a $50 gift card to Blue Moon Emporium in Appleton. So be sure to check that out, and you might win a $50 gift card there. So I end this by saying thank you to everybody for coming. I'll hopefully see you the rest of the week as well.
Thanks, everybody. Take care.
Take care.